For this election, some voters will notice a referendum on their ballots called Property Tax Dark Store Loopholes, which comes from the dark store theory. To break it down, both homeowners and big stores pay taxes. But if a big store wants to lower its property taxes, it can appeal to a court by comparing itself to a dark or vacant store. As a result, lowered property taxes for big stores shifts higher property taxes to homeowners in the community.
This is two loopholes in Wisconsin property tax assessment law that is allowing large properties, particularly commercial properties, to have their assessments reduced well below what it costs them to build their buildings. What a common man would say, oh, that building is a $10 million building. No, these dark store loopholes allow them to get that assessment shaved in half or less. And the way assessment law works in Wisconsin, that tax burden just gets shifted to everybody else. It's an issue of fairness.
Did it grow out of the 2008 Supreme Court opinion? Is that the genesis here, Jerry?
Walgreens versus the City of Madison, absolutely. That's where it all started. That was a leasing case, but since it's morphed, leasing is a problem, but it's morphed into property that's owned by large retailers as well.
We've heard the word loophole used a lot today. We don't have there's no such thing as a dark store loophole. We have Wisconsin tax law, assessment law, and the assessment manual. And really what this legislation is an effort to legalize what has been, for the past 10 years or so, an unlawful assessment practice. Unlawful practice that was determined. We've heard a lot about the Walgreens case in 2008, but ever since then, every court that has reviewed the attempt to tax to the max has some of these tax collectors have been very aggressive with and assessors with what they're doing. They've lost in court.
Let's talk about Walgreens in the state of Wisconsin. We have 227 stores in the state of Wisconsin and one distribution center. We employ almost 8,100 people in the state of Wisconsin. Last year, in real estate taxes, we paid just under $12 million. In personal property taxes, we paid just over $1.5 million. So total in property taxes in the city or in the state of Wisconsin, we paid about 13.5 or a little bit over 13.5 million last year. We don't mind paying taxes. We want to be a member of the community. We are a good member of the community. Just like any other taxpayer, we want to pay only our fair share of taxes.
The league has provided a graphic here showing a potential shift of $187 million. Can you talk about that?
Sure. If you play this out, property tax assessment has to be uniform, right? Says so right in our Constitution. So if this loophole is not plugged, at some point in time, we will have to basically downsize the assessments of all major retail in Wisconsin, and that's then going to seep out into manufacturing. It's going to seep out into small retail. And before you know it, homeowners who are already paying 68% of the property tax bill will pick up 3/4 of it.
In Appleton, we've had a couple cases with some stores. It's interesting that some of the opponents say assessment should be based on bricks, sticks, and mud, right? And so the assessor goes, it's been a recent sale, you assess at what the sale price was, and then you get a lawsuit saying, yeah, but it's really not worth that. And you lose. So you have a store that was purchased on the market for $4 million, and now we can only assess it at $1.8 million.
The city of Wauwatosa, which is about 48,000 people, currently has 12 cases. We have 12 active appeals right now on multiple year assessments. So it's not just that the appeal comes in one time and is adjusted. It is year after year after year. In 2013, we had 5 appeals. In 2014, that increased to 7 appeals. And now for 2016, we have 12 appeals. We recently had a Walgreens property that came in to contest their assessment, and within a week after that, the property sold for $8 million, and they were claiming it was worth under $4 million.
We had a previous speaker say this is a national issue. I mean, look, the only other state that's done what's being proposed here was Indiana, and they repealed their law. I mean, I would urge you all to not put Wisconsin in the position of allowing local governments to use, above market triple net leases as an opportunity to essentially extract an income tax on the value of lease income. I mean, I don't know why we would think it would be good public policy.
I don't think inaction is an option. This is something that really requires a legislative fix because of the court's interpretation of the existing statute. Municipalities are being placed in a position where they have to choose between following existing case law or the Department of Revenue's property assessment manual, or anticipating an increasing number of legal challenges from a lot of big box retailers following recent court decisions using an assessment standard that is inconsistent with the assessment of other property. The considerations for municipalities already operating under strict fiscal constraints is not just about the lost property tax revenue, but about the cost benefit of continued costly legal fights against well-funded national retailers, given the increasing trend of court decisions ruling against municipal assessments.